everyone. I hope you are having a great day. I am Bernice, and let's get right into it. We have another chapter to do a review for. And as you know, that's exactly what these little short video clippings are, like 15 minutes or less. That's what they are here for. They are reviews. So make sure you are reading, you're paying attention in class. They are very effective, especially when you're dealing with online real estate classes. This can really help you. So that's the purpose of it. This is the review for Chapter 6. As you know, Bernice needs these glasses at times too. For Chapter 6, Chapter 6 basically is violations of license law, penalties, and procedures. So this chapter is dealing with, number one, how do you lodge a complaint against a licensee? What can be some of the penalties, and what are the procedures going forth doing with it? So on page 118, 119, a lot of those words, guys, we've already covered. We've already covered commingling. You know you can't go mixing personal funds in with the escrow account. There is a certain amount, which you should know, of your own private funds that you are allowed to keep in the sales escrow, and the amount that you are allowed to keep into property management escrow. Concealment, withholding of information, conversion. Broker may not use earnest money fund for their own personal. That's what that is. Over on page 119, failure to account for and deliver. Brokers, if you are going to hold escrow, make sure that that escrow is deliverable upon closing. Fraud, intentional deceit, and reliance on the deceit of the persons of inducing another person to rely on deceitful information. Well, we don't want to do that. Material facts, make sure that you are stating the correct material facts about the property. Misrepresentation is an untruthful statement of fact. Moral turpitude involves conducts contrary to honest, good morals, justice, or acceptable custom. Be careful with all of those. So make sure that you know those definitions. One of the things concerning definitions, guys, one thing that may help you, put them on your little index cards, the definition, and then study it that way. I'm finding that a lot of students are using that, and it's very effective when they do it that way concerning your definitions. Okay, on page 120, the complaint process. So if you have a complaint against a real estate agent or real estate corporation or real estate instructor, the complaint process is down below, page 120. You have 7 steps. Number 1, you have to file the complaint. It has to be in writing. Number 2, from there it goes to the DBPR. That is the investigation of the complaint. They are the ones that will handle it. Number 3 is a probable cause determination. From there it goes to, from the DBPR department, number 2, investigation complaint, is going to go to the probable cause panel. Probable cause panel consists of at least 2 members of the FRAC. Remember, we have how many members? You've got 7. It could be one that's current on the board right now, and one of the members that was current a while back. So they may not be active as a FRAC member now, but they may be one of the probable cause panel on that panel. It could be one that is unlicensed. Out of the 2, remember the 7 that you have, there's 2 that's non-licensed. So it could be one that's non-licensed and one that is licensed. But that's a probable cause panel. Basically what they're doing is exactly what that department name kind of states. They are going to look over the case to see really is there probable cause concerning the complaint that has been lodged against that person. And from there, it will go to, if in the event, if they're found, if they don't see that there's probable cause, it will probably be dropped, and they'll just send a notice over to the person who sent the complaint in, stating that in a form of a letter. If in the event that it goes forward, you will be number 4. You have a formal complaint. It is issued if probable cause is found. So that's what I'm saying. So if they find that, okay, yeah, there is probable cause to proceed forward, it may go to a formal complaint, administrative judge, or if it is informal, it's going before the FRAC to a hearing. They will make a decision, a final hearing. That's your step 6. Final hearing will take effect 30 days after the hearing has been stated. And at that point in time, depending on what the final hearing is, if the A person wants to appeal, yes they can. That's your step 7, judicial appeal review. That's what you're looking at from there, okay? So make sure you know those 7 steps, what's going on in it. Another thing, on page 121 in the filing of the complaint, look at your line 5 through 6. You have a definition. Here again, put these definition guides on index cards. They will really help you. A complaint is legally sufficient if it contains facts indicating that a violation of any of the following has occurred. So, in the process of that, if they determine that, number 1, a Florida statute has been violated, or any existing legal enacted DBPR rule has been broken, any existing legal enacted FREC rule has been broken. Now it seems like there is legally sufficient enough that there is a complaint actually that may be going forward. Okay, and here again, it'll go to the investigation department. From there, it goes to the probable cause panel. Make sure you're clear on that panel, who is in it, things of that sort. Make sure you're clear on who is in the informal hearing. That goes before the Florida Real Estate Commissioners. Formal hearing, that will go before an administrative law judge. Final order, remember, it takes effect 30 days after that decision. And of course, if they want to actually do an appeal, they can. So if you look on page 125, it tells you concerning those appeals. Let's just say if in the event that the licensee, the final decision was to suspend the license or to revoke the license, it specifically states you can do the appeal. If you do that, line 4 tells you the licensee may request a stay of enforcement. This will stop the enforcement of suspension or revocation, and in order to do that, they have to maintain a writ of supersedence. That comes from the District Court of Appeal, and that is what we'll use to be able to stay in enforce. So those are your 7 steps. Make sure, guys, that you are clear with those 7 steps of the complaint step. If you go on over now to your page 126, 127, what are some of the penalties? On 126, they talk about the administrative penalties. Administrative penalties can go from civil, administrative law, civil, and criminal penalties that you can have lodged against you. And let's look kind of quickly upon them. Now remember, this is the second time that you're seeing this as well. Under administrative penalty, it tells you on line 6 and 7, the commissioners cannot issue a penalty of incarceration, which is a jail sentence. They do not have the authority to order restitution to an injured party. So therefore, it will go to another particular area from that point in time. 127, one of the things they can do, the denial of license application and refusal to recertify a licensee for renewal. Those are some of the things that they can do. That will be listed under as one of the administrative penalties. But quickly, let's go over to page 128. On 128, some more in the gray box. I love how she does this gray box. She summarizes, basically I'm just going over also what she's summarizing as well. The types of administrative penalties. You've got, we already went over the one, denial of application. Your application could be denied, or refusal to even renew the license. That may be one of the penalties. Letter of reprimand, notice of non-compliance. If you get a notice of non-compliance, remember guys, you got 15 days to correct the minor infraction. Citation. Citation is, now so once you get your, I look at it this way, once you get the notice of non-compliance, yeah, you're out of compliance, make sure you get that sign on the door, and here's the bill, okay? The bill is your citation, guys. That can range from $100 to $500. Probation can be one of the administrative penalties. You can have suspension of your license up to 10 years or revocation of a license, which is a permanent thing. Make sure you understand, suspension may be a temporary thing. It can go up to 10 years, but revocation is a permanent situation is what you're looking at there. Okay, and then if you flip on over here again, make sure you're reading that information. Going over to your page 132, you have some different, in the criminal penalty area, remember you had administrative, civil penalties and criminal penalties. Your civil penalties on page 131 may be enforced by the courts if an unlicensed person performs real estate services or a licensee commits fraud in a real estate transaction. Now you're looking at the civil aspect of it. Criminal penalties, flip on over. Here again, it's so good, guys. Another way you can do it to help you remember, to help you learn, put it on your little index card. Administrative penalty, bam, bam, bam. Civil penalties, bam, bam, bam. And then your criminal penalties. Here we go. You've got third degree, first degree, second degree. Third degree, practicing real estate without a real estate license. You can be fined up to $5,000 and or 5 years in jail, okay? And remember, practicing real estate without a real estate license for, don't forget that, for what? Compensation. First degree misdemeanor. First degree, that's failing to provide current rental information for a fee. $1,000 can go up to $1,000 or up to 1 year in jail. And then your second degree misdemeanor, criminal violation, for example, false misleading advertisement. That's a second degree. You can have that can go up to $500 or by imprisonment for more than 60 years. Here again, index card, put it on there, dude, that works. If in the event that you are found guilty of those, any of those particular things, and let's say you don't have the money for it, there's a fund, the recovery fund, real estate recovery fund. I know you've read about it. On page 133 in the gray box, the key concepts, guys, those are excellent for it. It tells you who actually can borrow from that fund. It tells you how much you can borrow from it. You got the $50,000 per transaction, $150,000 maximum amount. Remember, punitive damages cannot borrow for punitive damages. What are they? There are any damages outside the damage to the property, like your attorney fees, your court fees. You cannot borrow from that fund here. The only kind of exception to the rule is that last one, the last bullet where it says a broker who complies with an escrow disbursement order and is later sued. If you're complying with the Florida Real Estate Commissioners are telling you to do, and then you get sued anyway, at that point in time, all your fees will be covered from the recovery fund. Okay? Make sure, especially this gray box here, guys, put it on the index cards, okay? Go over it. If you have any questions, give us a call, let us know. That is super duper for your chapter 6. Let's take a quick break and then we'll go over your primary things for chapter 7.